Next topic in consideration is exception to the rule. Contract without consideration is void. No consideration, no contract. The general rule says that agreement made without consideration is void. Section 25 and 185 dealt with the exception to this rule. In such cases, agreements are enforceable even though they are made without consideration. So it means that there are certain agreements are made without consideration, and all those agreements are enforceable even though they are made without consideration. This is the meaning of exception to the rule. The first case is love and affection, section 25, subsection 1. Where an agreement is expressed in writing and registered under the law based on natural love and affection between the parties, standing in near relation to each other, is enforceable even though it is without a consideration. When I say about near relation, it can be a father and son, husband and wife. For example, a father, by reason of natural love and affection for his son, by a writing and registered agreement, promised to give him rupees 1,000 as a pocket money every month. This is a result of a contract. But nearness of relationship, however, need not necessarily imply natural love and affection. For example, a Hindu husband, after having a fight and disagreement between his wife, executed a registered document in favor of his wife, agreeing to pay her maintenance. But the court held the agreement was void for want of consideration. The essential requirement, the natural love and affection between the parties, were missing. So it was not enforceable. Next one, compensation for voluntary services, section 25, subsection 2. A promise to compensate wholly or a part a person who has already voluntarily done something for the promiser is enforceable, even though without any consideration. For example, A says to B, at the risk of your life, you saved me from a serious accident. A promised to pay rupees 10,000 to B. So there is a contract between A and B. Next one, promise to pay a time barred debt, section 25, subsection 3. A promise by debtor to pay a time barred debt is enforceable provided such promises is made in writing and is signed by debtor or his agent. The debt must be such that the creditor is unable to enforce payment because of Law of Limitation Act. Promise by debtor may be to pay the entire or any part of the debt. A debt becomes legally irrevocable if it remains unpaid or unclaimed for the period of 3 years. Next one, completed gift as per section 25. A gift actually made by a donor, a person who donates, and accepted by a donee is valid even though it is without any consideration. For example, A purchases and donates an ambulance van to a village hospital, and the transaction is valid even though it is without any consideration. Next one, no consideration is necessary to create an agency. The fact is that the principal allows the agent to represent him on behalf of principal is enough consideration to support agency. The last one is guarantee by surety, section 127. We have separate chapter in Indian in legal aspects of business. I'll give the meaning here. In a contract of guarantee, there are three parties, namely the principal, debtor, creditor, and surety. Surety is a person who gives guarantees for repayment of debt by the principal debtor to the creditor. But the question is, what is the benefit the surety will get in a contract of guarantee? According to section 127, any promise made by the benefit of principal debtor may be a sufficient consideration to the surety for give the guarantee. Consideration received with the principal debtor is sufficient for the surety. It is not necessary that surety himself must derive some benefits. Next we will see exception to the rule. Stranger to a contract. Stranger to a contract cannot sue. As per the Indian Contract Act 1872, a person who is not a part of contract is known as a stranger. But there are certain exceptions to it. Even though he is a stranger, in certain cases agreements are enforceable by stranger. First one, in case of trust or charge. A person in whose favor a trust or other interest is created can enforce even though he is not a part of a contract. For example, A agrees to transfer certain properties to be held by C in trust for the benefit of B. B can enforce the agreement, therefore the trust, even though he is not a party to the agreement. Next example, family arrangement. For example, two brothers on a partition of a joint property agreed to invest an equal share on certain sum of money for the maintenance of their mother. Held she was entitled to require her sons to make the investment. Next, acknowledgement or estoppel. The promisee by his contact acknowledges or otherwise constitute himself as an agent of a third party. A binding obligation is thereby incurred by him towards a third party. For example, A receives some money from B to be paid over C. A admits of this receipt to C. C can recover the amount from A, who shall be regarded as agent of C. Next one, assignee can enforce. Assignee have rights and benefits under a contract not involving personal skill. Can enforce the contract subject to the equities between the original parties. Next one, principal can enforce a contract made by his agent. Principal can enforce the contract entered into by his agent provided the agent acts within the scope of his authority and the name of the principal. The last one, condition attached to immovable property. In case of transfer of immovable property, the purchaser of land with the notice that the owner of the land is bound by certain conditions created by an agreement affecting the land shall be bound by them, although he was not a party to the original agreement, which contained the conditions attached to the immovable property. The learning outcomes of summary. We have discussed about consideration, legal rule has to consideration, agreement without consideration is void. We have seen certain exceptions to it, stranger to a contract, and we have seen certain exception where stranger can also sue a contract. Thank you, students.